have chosen to request consideration of this Bill of Rights Ordinance as they feel it in proper manner to ensure the protection, security, and benefit of their rights, which is the government's sole purpose for existence. Our Declaration of Independence establishes that to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed. James Madison said, government is instituted to protect property of every sort, as well as that which lies in the various rights of individuals. This being the end of government, that alone is a just government which impartially secures to every man whatever is his own. Sebastian County would not be creating itself as a newly declared sovereign, as is alleged. Every county is clearly, by Constitution and Code, sovereign in its delegated capacity. The oath of office makes it clear that it is the duty of every elected person to support the Constitution of the U.S. and the state. And in that duty, solemnized by oath, every elected person must support and defend the provisions of those documents above the law, as there is no specific reference in the oath to obedience to law. We must deduce that the omission of, quote, obedience to law in the oath is a recognition that it is possible for law to be created contrary to constitutions. And therefore, an oath, a promise to obedience to law, would then contradict the Constitution itself and be impossible. If elected county officials have no authority to support and defend these constitutions above the law, then their oath becomes nugatory. I will also point out that the oath of office does not predicate this duty and promise to the people upon the designation, definition, or act of any other division of government or political entity. Since the language of the oath is personal and individual, each person elected to office, in their duty to their oath, must also possess the authority to independently, as well as corporately, act upon that oath. If they do not, then the oath is useless. One of the oldest, most powerfully peaceful, and more importantly, most recognized mechanism for acting upon that oath is the authority to declare every act contrary to the Constitution null and void. James Wilson said, anything enacted by Congress contrary to the Constitution will not have the force of law. Alexander Hamilton said, no legislative act, therefore contrary to the Constitution, can be valid. What's interesting is Hamilton went on to make a warning. He said to deny this principle would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but also what they forbid. To emphasize this point, we only need to look to the Supreme Court of the United States in NFIB v. Sebelius. In the majority opinion, Chief Justice Roberts explains the existing duty to not comply with unconstitutional acts or laws. And I quote, he says, in the typical case, we look to the states to defend their prerogatives by adopting the simple expedient of not yielding. The states are separate and independent sovereigns, and sometimes they have to act like that. Through the application of Kris v. U.S. and California v. U.S., we can understand that this principle is true for the states, must also be true for the county and the municipality. With a multitude of examples, there ought to be no fear in implementing this long-standing principle of refusing to comply with unconstitutional acts of government. If the Supreme Court follows their own recommendations and precedent, there is no credible threat for successful litigation against a county that refuses to enforce any law or ordinance contrary to the constitutions. Finally, Mr. Rainwater also references the Amendment 14 as grounds for the county to not consider the ordinance. However, legal precedent agrees that this ordinance does not violate Amendment 14. Now, Amendment 14 refers to local or special acts that would be unique or special laws for that county. As Mr. Rainwater acknowledges, there is nothing unique or special in the proposed ordinance, but everything that is already required by every state, county, and municipal officer. The purpose of the ordinance is to specifically require the county to adhere to the Constitution of the United States and the Constitution of the State of Arkansas as demanded by their oath. Now, in reference to Amendment 14, the Supreme Court of Arkansas, I'm sorry.
Okay.
In reference to Amendment 14, the Supreme Court of Arkansas, in explaining the proper application of Amendment 14 in Layman Mayor v. Harrell, they quote State ex rel Borough v. Jolly. In determining whether a law is public, general, special, or local, the courts will look to its substance and practical operation rather than to its title, form, or phraseology, because otherwise prohibitions of the fundamental law against special legislation would be nugatory. A substantive and practical operational view of the proposed Bill of Rights Ordinance indicates it is not a special law and would be authorized under both county's delegated authority and the right of the people as a power inherent in the people. The people are simply asking the county to consider this ordinance to secure their rights. Recent events give people justifiable concern regarding those elected under the trust to secure the rights of the people. We may not prevent an elected oath taker from wandering away from their duty, but we can reduce that temptation for the person in office to lose sight of their promise with a constant, visible reminder of that vow. History proves it is more than appropriate for the people to call for those elected with the trust of securing their rights to be reminded of that vow and have the appropriate political recourse to answer when that vow is broken. To say the people do not have that authority or that some law prevents that authority is to admit that the representatives of the people are superior to the people themselves. And then you will see men acting by virtue of powers do not only what their powers do not authorize, but also what they forbid. Thank you.